So imagine you're standing on this really quiet beach,
Okay.
and you pick up just a tiny, insignificant pebble, and you toss it into the ocean.
Right.
It makes this little miniature splash, maybe a few ripples, and then, it's just gone. But then the next day, authorities show up at your door.
Oh, wow.
Yeah. They arrest you, claiming that your specific pebble somehow caused a catastrophic tsunami on the exact opposite side of the world.
I mean, it sounds totally absurd when you frame it that way because,
Yeah.
we naturally expect causality to be this physical, provable chain. Like, if you are accused of causing a disaster, there has to be some measurable link between your action and that huge macro-level outcome.
Exactly. But what happens when a legal system decides it just no longer needs to measure those ripples?
Yeah, what if they just skip the math entirely?
Right. What happens when authorities simply substitute an abstract assumption for actual physical evidence? So, welcome to today's deep dive.
We've got a fascinating one today.
We really do. We are exploring a truly unprecedented collision between complex systems, physics, internet law, and, believe it or not, artificial intelligence.
The source stack for this is just incredible.
It's wild. Our stack today includes official court documents, a really dense 20-page legal defense, which mathematically calculates innocence, by the way, written from a prison cell.
Which is just a crazy visual.
And on top of that, we have comparative analyses of this exact case generated by 6 major AI models. We're talking ChatGPT, Gemini, DeepSeek, Copilot, Qwen, and Grok.
It really is an extraordinary collection of texts. I mean, we are essentially examining how a physicist used pure mathematical theorems to defend himself against a super vague legal charge,
Yeah.
and then how entirely non-human intelligences evaluated the logic of his defense. But before we get into the mechanics of all this, we really need to establish some ground rules for our deep dive today.
Absolutely.
Because, our source materials contain politically charged content, and they are actual legal documents regarding a criminal conviction in China. So we want to be completely clear with you, the listener. We are remaining entirely impartial here.
Right. 100%.
We're not endorsing any political viewpoints. We're not validating the defendant's actions. And we aren't endorsing the court's decisions either.
Yeah, our role is strictly analytical.
Exactly. We're just here to unpack the legal, the scientific, and the structural facts. Just to explore the really fascinating ideas embedded within all these texts.
So let's get right into the facts of the case. We are looking at a man named Dr. Chen Jingyuan. He's got a PhD in physics and complex systems.
A very smart guy.
Very. And in September 2022, he was arrested in Kunming and eventually sentenced to 1 year and 8 months in prison.
And his offense.
Right, his big crime was using a VPN to retweet posts on Twitter.
And, the scale of this activity is really what sets up the entire scientific conflict later on. We have to look at the actual numbers here.
The numbers are incredibly small. Like, Dr. Chen had fewer than 100 followers.
Wow.
Yeah. And the data in the sources shows most of those were actually inactive, so-called zombie accounts anyway.
So nobody's really even seeing this.
Pretty much. Over a 20-year period, his total retweets amounted to fewer than 100.
20 years.
Yeah, 20 years. And the content was just a mix of things that already existed out there on the internet. He retweeted some art, like a comic called Umbrella Girl, an image of a candle expressing emotion.
Pretty standard internet stuff.
Exactly. There were some speeches by U.S. politicians critiquing communism and some historical edits to textbooks. Nothing he actually made himself.
But for these actions, he was charged with a crime that translates to picking quarrels and provoking trouble.
Right.
And legal analysts in the source texts often refer to this specific charge as a pocket crime.
Which is such an evocative term, a
Yeah.
pocket crime. I was thinking about it, sort of like a junk drawer in a kitchen.
Oh, that's a great analogy.
Right. Like, authorities can just throw whatever behavior they decide is undesirable in the moment into this drawer, even if it doesn't fit into a highly specific legal statute.
Yeah, it expands to fit the need.
But taking a step back and just looking at the mechanics of this charge, if a user is simply hitting retweet on a speech from an official embassy account or some historical text, how does the prosecution logically define that as the user fabricating a rumor or disrupting society?
Well, that structural question is exactly where the court's logic begins to really fracture. Because to secure a conviction for this specific crime in an online context, the written law explicitly requires proof of a tangible outcome.
Okay.
The statute literally demands that the behavior caused, quote, serious public order disruption.
Meaning it's not enough to just harbor a dissenting thought or just click a button in your living room. The action has to bleed into the real world.
Precisely. And judicial interpretations actually go out of their way to quantify this. They state that a serious disruption means the post was retweeted at least 500 times or viewed 5,000 times.
So there are hard numbers.
Yes. Or it has to have caused measurable real-world panic, riots, paralyzed public services, things like that. It is technically classified in law as a result crime.
And this brings us to the massive void at the center of the prosecution's case.
Yeah.
There is absolutely zero evidence of this disruption.
None at all.
Right? No public opinion monitoring reports were filed. There was no evidence of real-world panic anywhere. And the craziest part, there were zero actual retweets of Dr. Chen's posts by any other users.
Zero. So the court was facing this massive legal hurdle. They had a strict statutory requirement for quantifiable evidence of a serious disruption.
And an utter lack of that evidence.
Right. So to bypass this, the court engaged in a maneuver that the AI analyses we looked at refer to as the virtualization of the legal elements.
And the mechanics of how they did this are fascinating, but honestly also pretty terrifying.
Oh, definitely.
Since they couldn't find evidence of a tsunami, going back to our analogy, they used Dr. Chen's own intellect against him.
Yeah, this part is wild.
The court argued that because he has a high education level as a PhD, he, quote, should be able to distinguish right from wrong. Therefore, they argued, he possessed the subjective intent to cause disruption.
Right.
By proving his intelligence, they believed they proved his intent. And by proving his intent, they just presumed the disruption actually happened.
Yeah. In jurisprudence, this is known as result element nullification.
Result element nullification. Okay.
Yeah. They basically took a crime that demands a physical result and hollowed it out until it was merely a behavior crime. They substituted an abstract label, his level of education, for the actual empirical evidence required by the law.
That is essentially like prosecuting someone for a noise complaint just because they own an unplugged megaphone.
Exactly.
You know, like you have undeniable proof they never turned it on, but you are punishing the theoretical potential of the megaphone rather than the measurable reality of the noise.
You're bypassing the causal link.
Right. They entirely bypass the link between the pebble and the wave.
Which fundamentally violates the basic principle of evidentiary adjudication. And, you know, this is where the narrative shifts in our deep dive, because Dr. Chen, being a complex systems physicist, he recognized this structural logical fallacy the court was employing.
He saw right through it.
Yeah. He realized that if the court was going to substitute circular logic for empirical evidence, he would use his prison defense to mathematically calculate why their logic was literally impossible.
I love this part. He didn't just argue standard internet law. He actually submitted a multi-tiered defense based on complex adaptive systems theory.
From a prison cell.
Right. And the math here is just phenomenal. He started by examining the very nature of social media platforms through the lens of scale-free networks.
Right. So to understand a scale-free network, imagine a map of airline flights.
Okay.
Most airports only have a few connections, right? Like a small regional airport. But a few massive hubs like Atlanta or Heathrow, they have thousands of connections.
Right. All the spokes lead to the hub.
Exactly. The internet operates the exact same way. A few massive celebrity or media accounts are the hubs, but the vast majority of normal users are marginal isolated nodes.
And Dr. Chen proved he was one of those edge nodes. He also cited the CAP theorem, which explains that in massively distributed systems like the internet, chaos and localized inconsistencies that are actually built-in features, they aren't bugs.
Right.
So you mathematically cannot blame a single edge node for the inherent noise of a massive macro system.
He is directly attacking the prosecution's core presumption of causality here.
Yeah.
The court basically assumed his one retweet could cause a massive public disruption. Dr. Chen is stating that, mathematically, a node with fewer than 100 zombie followers simply lacks the kinetic energy to force a macro-level phase transition across a network of billions of users.
And he actually brought the receipts. He applied the Galton-Watson branching process.
No, the math gets so good here.
It really does. This process was originally developed in the 1800s to study the extinction of family names. But today, scientists use it to model how things spread, whether that's a biological virus in a pandemic or a viral tweet on social media.
Yeah.
He combined this with Cohen's critical threshold formula.
And this is where we get into creator of the dollars, the reproduction number.
Right. Like we heard about during the pandemic. If you think of his social network as a physical environment, we need to know if it's a humid forest or a dry brush box.
That's a great way to picture it.
If trader dollars is greater than 1, every person who sees the tweet shares it with more than one person. The spark lands in dry brush, and you get this massive exponential cascade.
But Dr. Chen demonstrated that his account was buried deep in a subcritical zone. His followers were largely inactive, therefore his average branching number, his dollar, was drastically below 1.
Way below.
Yeah. And when TRIALIS is that low, the Galton-Watson process dictates that an avalanche of information isn't just improbable, it is the extinction theorem.
Extinction theorem.
Yes. The information is mathematically guaranteed to die out. Lighting a damp match in a room with no oxygen will never, ever burn the house down.
Okay, let me push back on this just a little bit, though.
Sure.
Because we hear about the butterfly effect all the time in complex systems, right?
Yeah.
The prosecution's implicit underlying fear here seems to be that one tiny perturbation, one butterfly flapping its wings, could theoretically trigger a massive storm.
Right. The idea that small inputs lead to massive output.
Yeah. So what if the social network was already a dry brush box? Couldn't his one tweet theoretically be the spark that sets off a highly volatile system?
It's a completely valid challenge, and the brilliant thing is, Dr. Chen anticipated it.
Did he really?
He did. He pivoted from physics directly back into statutory law. He specifically cited Article 16 of the criminal law, which deals with foreseeability.
Okay.
He argued that for the butterfly effect to actually occur, the entire macro system must already be hovering in a highly unstable, supercritical state.
A state that he obviously doesn't control.
Exactly. If his tiny retweet did somehow miraculously trigger an avalanche, it would only be because the system was already on the absolute precipice of collapse anyway.
Wow.
And under Article 16, if a harmful result occurs from underlying causes that a normal person could not possibly foresee or control, it is legally classified as an unforeseeable event, an accident.
So he completely traps the court's logic.
He really does.
If the system is in a normal state, his post mathematically goes extinct and no harm occurs. If the system is so fragile that his tiny post causes a collapse, it's an unforeseeable accident, which means he lacks subjective intent and therefore it's not a crime.
It is an airtight, inescapable logical loop. He dismantled the causal chain from both sides.
That is incredible.
However, presenting a theoretical mathematical defense in a traditional courtroom is, it's incredibly difficult. Courts run on precedent and narrative, they don't run on network topology.
Which is why the third tier of his defense is just the most devastating part of this whole deep dive. We finally move from the theoretical math of a prison cell back out into the empirical world.
The real-world proof.
Right. It is the ultimate natural experiment. Because after serving his full 20-month sentence, Dr. Chen was released.
And as a scientist, he immediately sought to verify his hypothesis with real-world data, so he logged back into his social media accounts.
And the data was perfectly clear. All of those allegedly criminal posts, the ones that the court presumed would cause serious public order disruption, they were still sitting untouched on his timeline.
Still?
Over nearly 2 years, they had generated zero interaction. No new retweets, no comments, and furthermore, there were no official state rebuttals or takedowns of those specific posts.
The serious disruption literally never occurred.
Never.
The court's virtualization of the evidence was proven entirely false by reality. The court theorized that the pebble caused a tsunami, but 20 months later, the pebble was still just sitting at the bottom of a completely still pond.
It just highlights this profound tragedy in the legal system's methodology, something that's described in the source texts as witchcraft attribution.
Such a powerful phrase.
It really is. The judicial system was operating on this almost pre-scientific belief that merely whispering a bad thought could tear down a city wall. And they completely ignore the 21st century physics, proving that the whisper never even left the room.
Yeah, witchcraft attribution perfectly captures the disconnect. It is the substitution of an abstract, authoritative fear of what might happen for the tangible, empirical evidence of what actually happened.
So we have this defense built on scale-free networks, the extinction theorem, statutory foreseeability, and post-release empirical data.
A lot of heavy concepts.
Yeah. So how do you objectively evaluate a defense that complex, especially when human biases are obviously involved?
Well, this is where we get to introduce the 6 different artificial intelligence models.
Yes. ChatGPT, Gemini, DeepSeek, Copilot, Qwen, and Grok.
This is perhaps the most revealing part of the entire deep dive, because we are talking about 6 distinct neural architectures.
They don't all think the same way.
Not at all. They have different training data weights, different system prompts, different reinforcement learning mechanisms. Yet, When they were fed the court documents and Dr. Chen's defense, they reached a completely unanimous digital consensus that the court's logic was structurally flawed.
Let's actually break down how they process this, because looking at why they produce their specific outputs tells us so much about how machines interpret human law.
Let's do it.
ChatGPT, for instance, it focused heavily on the structural failure of the legal process itself. It methodically mapped how the burden of proof just seemed to vanish as the case moved from the police to the prosecutor to the court.
Right, and then you look at Copilot and Quinn, they operated much more like strict, literal engines of statutory interpretation.
It's just sticking to the rules.
Exactly. Their architectures excel at rule matching. They looked at the legal requirement, the rule explicitly stating disruption means 500 retweets, and they clinically matched it against the evidence variable, which was 0.
Just pure math.
Yeah, they mathematically highlighted the threshold failure without any emotion.
But then you have DeepSeek, which provided a much more philosophical analysis.
I love this one.
Me too. It highlighted the cognitive gap between the two parties. DeepSeek noted that the judicial system simply lacked the scientific literacy to process a defense based on network topology. The court was speaking the language of authority, while Dr. Chen was speaking the language of physics.
And Gemini offered one of the most compelling metaphors, I think. It called Dr. Chen's defense a cross-dimensional strike.
A cross-dimensional strike.
Yeah. Gemini pointed out the philosophical flaw of subjective presumption, how the court basically weaponized his intelligence to bridge a void where physical evidence should have been.
And finally, Grok zoomed out to this massive civilizational level. It viewed the entire case not just as a localized legal error, but as a clash between the foundational principles of logical, evidence-based civilization and the unchecked abuse of judicial power.
What really binds all these AI analyses together is the stark contrast between algorithmic processing and human institutional processing.
Right.
The AIs evaluated the causal chain impartially. Did action A lead to result B, as strictly defined by law C? To an AI, if the data is absent, the equation simply fails.
The AIs required empirical data to reach a conclusion. The human court only required a label.
Yeah.
It's a remarkable indictment of how human institutions can sometimes just bypass their own codified rules when it suits a specific narrative.
Which brings us to the core relevance of this deep dive for you, the listener. Because, why does a specific localized court case regarding an edge node on Twitter actually matter to your life?
Right. Why should we care? Because if you interact online at all, you are a node in a scale-free network.
We all are.
This case reveals the profound danger of living in highly interconnected systems where authorities, and that could mean legal systems or corporate moderation algorithms, or even your employer, might substitute their abstract fears about what your data could do for empirical facts about what it actually did.
It also underscores the absolute necessity of scientific literacy today.
Yes.
Dr. Chen's understanding of complex systems wasn't just some niche academic pursuit for him. It was a tangible shield. It provided him with the precise vocabulary to articulate exactly why the assumptions made about him were physically impossible.
Logic, mathematics, and understanding of data. These are not just tools for scientists in a lab anymore. They are essential mechanisms for defending truth against circular logic in everyday life.
They really are.
If you don't understand the mechanics of the system you are participating in, you are entirely at the mercy of how someone else defines it.
That leads us to a critical, overarching question about the future of our institutions.
How about that?
Well, we just observed 6 independent artificial intelligences effortlessly dismantle a flawed human judgment using pure logic, physics, and statutory law.
Yeah, they tore it apart.
So as these AI systems become increasingly integrated into our legal and governance structures, will they force human courts to abandon this virtualization and adopt strict mathematical standards of proof? Or will human institutions continue to resist mathematical truths whenever those truths conflict with the narrative of authority?
Oh man, it is the ultimate tension of the modern age. The immovable object of institutional authority versus the unstoppable, verifiable force of empirical data.
It really is.
It certainly leaves you wondering what happens next time you find yourself standing on that beach.
Yeah.
If you toss a pebble into the ocean and the system tries to hold you accountable for a tsunami, will you have the mathematical literacy to prove them wrong? Or will the system just completely redefine what a tsunami is?
It's a lot to think about.
It is.
Yeah.
Thanks for taking this deep dive with us. Keep questioning the ripples.